Welcome to PocketExperts.Solutions. This event is for educational purposes. The terms and conditions and the privacy policy apply as posted on the PocketExperts.Solutions website. Today, our guest expert is Doug Tibble. Welcome, Doug.
Hello, Mark. How are you?
Good. As a lawyer closing complex commercial transactions and litigating business disputes over 30 years, he organizes a project team with his clients and other stakeholders, consultants, and professionals to efficiently and effectively achieve his clients' goals. Whether through negotiating to complete the transaction or resolving the dispute by a lawsuit, mediation, or otherwise, his goals is always to resolve the problems to his clients' satisfaction with the least cost and delay. Whether working with a single owner, local branch of larger entities, or a major corporation, he knows that budgeting, planning, and managing the project is most important to all of his clients, and that cooperative partnering with his clients garners the best result. As general counsel for many businesses, families, and organizations, he counsels and assists his clients in getting the best and most appropriate legal and other services and advice, whether provided by his firm or other professionals in his network that he is confident that will provide the best services. Today, Doug, we're going to talk about protecting confidential business information. As we attend the meeting, do you have any opening comments?
Yes, I do, Mark. Thank you. When I talk to my clients and business owners about confidential, proprietary, or trade secret information, they generally tell me, I don't have any of that. What's it matter to me? And then when I talk to them further, it's usually I start with, well, what makes your business different than the guy down the street that also does, your competitor, does the same thing, also prints, also sells chemicals, also does real estate or leasing? What's the difference? And they start to tick off the difference, and I start to say, well, would it be okay with you if your competitor down the street knew that? Oh, of course not. Of course not. Would it be okay if your employees left and started their own business competing with you using that information? Of course not. That leads us to discuss then, they do have, and most businesses have, some confidential or proprietary information or even trade secrets that they should and want to protect. Generally, a trade secret in the legal sense is kind of a formula, the recipe for Coca-Cola, famous Amos cookies, things like that that's unique and that you protect. But there are other things. Confidential information could be processes, costs, markups that you have. It's your business's confidential information that no one else knows unless they're in your business, and you should be protecting to keep it that way because it would give your competitors a competitive advantage. And then we have things called proprietary information. That could be your list of vendors, the phone numbers of your customers, or the decision makers at the customers, and other access that's really proprietary to you and gives you a leg up or a benefit on competitors in the area. We also talk to our clients about, they'll say, well, what about copyright and trademark and patent? And those are all applicable and provide protections for your business. Copyrights for formulas, software, documents you've prepared or written, that's available. Copyright protections are what they are. It's a limited time, and the Copyright Office gets those. So it's really made public by doing it. Trademarks, trade names, things like that. Certainly those should be protected. I don't think any of our customers would want, any of our clients would want competitors using the name of their name brand or their colors or their designs, their logos. And patent protection, again, that's formulas and processes that you have. Again, they're made public. There's a cost to patenting them, and at some point the patent lapses or runs out and they're not unique to you anymore. So trade secret protection is something we discuss with almost all of our clients, and I think almost all of our clients say, well, I do have that kind of information and I'd like to protect it. We also discuss there are some laws out there that protect some of your trade secret, confidential, and proprietary information, but they're rarely adequate to protect our customers, and the cost and the reliance on somebody else to do it for you just is not worth the effort. You need to protect them yourself. There certainly is a Federal Trade Secrets Act, which has become popular. It has criminal provisions, it has damage provisions, it has injunctive enforcement provisions, but again, costly, and if you've got to resort to that, it means you haven't done your own homework in protecting that information. There are certainly common law in every state, common law provisions about protecting trade secrets and confidential information. But again, the level of proof is difficult, and you're relying on someone else to enforce that. The level of proof being, in many states, historically, non-competition agreements or such agreements with your employees were thought of as restrictive trade, and were really against the law, and you had to work your way around those. So we tell our clients that what they need to do, or what they should be doing, is to work with us to help identify what they have, what they want to protect, and how they can protect it in order to keep the advantage their businesses have developed over the years.
Great. Let's start with our first question. Let's talk about identification, right? What confidential or proprietary information does your business generate or receive?
Well, let's break it down into two ways. What you generate. The confidential information could be, as we talked about, the process in which you make your product, what machines you use, what timing it takes, what temperatures it takes to bake or cook or process, what synergies are needed to come up with that final product. Those processes, machines, and formulas could be your protectable proprietary or confidential information. But even in sales businesses, we look at people developing their own confidential and proprietary information. Who do you contact? Excuse me. Having that contact information, we used to call it the Rolodex, but knowing who at that industry or that business or that customer do I contact? Who makes the decisions? Who's the purchasing agent? How do I get to that person? How do I get past the swarm of emails that they get every day so they get to the one who can make the decision for you? And what are their likes and dislikes? How have they worked with you in the past? All that kind of information becomes the real valuable information for a salesman and a sales force. So they have that information. That can be protected. There's also another kind of proprietary or confidential information that often needs to be protected, and that is what you receive from third parties. Oftentimes, if you're a manufacturer, you may get specifications, product requirements, formulas, or even assistance with processes from some of your customers or your vendors. Those you're going to have to figure out a way to protect. Oftentimes, the agreements with those customers or manufacturers or vendors require there be some level of protection of their confidential information which they've given to you. So we do sit down with our clients in our businesses and discuss with them both proprietary or confidential information you receive from others and how you should protect that, and the confidential and proprietary information your business has developed, acquired, or purchased, and how to protect that and make sure it's used only by your business.
Okay, excellent. Let's take a look at our next question. How is your business information collected?
We spoke about that, and there's several ways. One is if it's third-party information, it's obviously provided by that third party, by the vendor or the customer telling you, I want this made in this particular way, or this product should be handled in this particular way. But more importantly, we find our clients acquire it in 2 or 3 different ways. One is they may acquire it with a salesperson. You've brought in a sales staff or person or consultant who's got information about the particular customers for the products or services you provide. He's been in the territory. He knows the purchasing agents, whatever it is that he has, that you're willing to pay a premium to bring him on board. And when you do that, I think we usually discuss with our clients acquiring that proprietary or confidential information from him. That would be by written contract and agreement, and with the understanding of the provision that when that relationship terminates, you either own that agreement or that information, or you own it jointly. Certainly bringing him on board or bringing her on board to help with sales, only to let them leave with the same information exclusive to them, and perhaps with it being substantially enhanced by their relationship with you, is not a good idea. The third way to acquire that information is through the general operation of your business and its employees and representatives. You've got people out doing sales, acquiring that information, and typically we suggest to our clients that they ought to have a database or a centralized location to receive that information and to put it in a usable form, not just for the employee that generated, the salesman out there, but you have it, you owned it, you pay them, they work for you, they generate that information for you. Additionally, on your manufacturing floor, your purchasing department, that's the same thing. You want to acquire and keep that information and keep it protected so it's usable for you. It doesn't belong to the employee, it belongs to you. Generally, the law says the employee owns sort of his general knowledge in the industry and what he's learned working for you. That's one thing. But having access to all that proprietary information and the particulars of products, processes, vendors, customers, customer specifications, all that belongs to you, and it should be clear that it belongs to you when the employee generates it for you.
Okay, great. Who has access to your business information?
One of the first steps we discuss with our clients, once they've recognized they have proprietary or confidential information that they want to protect, and that's the information that separates them from the competitor down the street, is who's going to have access to that. If it's just generally available and sitting on the desk or open, it's an open source on your computer, anyone can punch in to give me the facts on this customer, what's his purchasing practices, what's his experience, who's the contact people, it becomes less and less valuable to you and less protectable by your business. One needs to decide what that information is, how to store it, and then kind of use as an as needed basis. We don't need to have that available to everybody and everyone. It certainly should be available to those people who need to use that information in their employment for you. But on the other hand, they shouldn't have access to the entire gambit or package of information you consider proprietary and confidential to your business. And those who do, even have limited access, should have some agreement, we'll talk about that, with you to protect that information, and some understanding, and we'll talk about that in policies and procedures, that they understand, they've been told, and they've acknowledged that it belongs to you, it's usable by them only for your benefit, and when they leave that information with you.
Okay. How do you share your business information?
In many instances, certainly in the manufacturing portion of a business, it becomes necessary to share some of your proprietary and confidential information with either customers or with vendors or suppliers. It normally happens, not unusual. You go to your vendor and you say, or your supplier, and say, I'm trying to make product X. What do you have, and what can you sell me, and how do I handle it in order to make product X, and what do I mix it with, and what mixes well and doesn't mix well, what has a good shelf life, what doesn't have a shelf life, those kind of questions. Similarly, you have situations, certainly again on the manufacturing end, in which the customer tells you, here's my specification, tell me how you're going to meet it, I'm going to test some of your products, tell me your processes, or they may suggest processes they think work, or which raw materials they want you to acquire to make that product. In all those instances, we recommend that our clients have a formal, either a non-disclosure agreement or a sharing of proprietary information and technology agreement, such that you know your technical expertise, to the extent you have to disclose it to either a customer or a supplier, is going to be protected, that the other side knows they have to protect that information, that at the termination of your relationship, that information will be returned and destroyed, so it can't be used for other purposes other than the joint project you're working on, and to provide that information does not belong to the other side, but comes back to you, and hopefully that whatever the result of that cooperative effort is also belongs to you. So if you work with the supplier to set up a process, a number of machines, or method in which to use his product to build or create the product you want, then in the end, you get that process. It's not shared with the vendor, so he can go to your competitor and say, look, if you buy these 4 types of machines, if you operate them in this fashion and this timing, you can come up with a competitive product. So we almost always provide at least a non-disclosure agreement, but also a sharing of technology agreement for our customers in those situations.
Doug, you've given us a lot to think about in a very general kind of format, and it's really been an outstanding discussion so far. As we continue on to our next question, do you track access to your business information? Another great question.
Yeah, and it's important for a number of reasons. One is just for protecting your information. Who copied it? Who entered into that database? Who copied the file? Whose equipment are they using? Where did it go? Who emailed it out? And what was the address of the email that received the equipment? All those are important. They're important, the information. They're important for you to manage your business and protect your information. They're also important in trying to enforce the protections of your information. Typically, a defense is, you didn't do anything to protect it. How did I know it was confidential or proprietary or valuable to you? It's just sitting on the desk. You know, the sales book was always out on the desk in the sales room. Anybody could grab it and use it. The access to the formulas or the processes or the files or the blueprints, they weren't password coded. Anyone could go in there. We all know the password. The password is 1234. So once you have to defend or protect your position, that's going to be their defense is, you didn't protect it, you didn't think it was valuable, you didn't spend any money on protecting it, you didn't lock it in a drawer, you didn't have a locked room, you didn't even have password protected computers. So it's important that you do that and that you provide that evidentiary trail. So in case we have to go to court to get an injunction or to obtain damages for the misuse of your confidential or proprietary information, we can demonstrate that. Someone can say, no, here's what we did. It was limited to need to know only. If you needed to get access, you had to go through the gatekeeper, you had to have the code, whatever it is. We also discuss with our clients, and I think it's important, that we like to have employees use employer-owned equipment, laptops, tablets, phones, and of course at the termination of that relationship, those need to be returned. And then we have a forensic consultant, if appropriate, can go through those and determine whether or not proprietary information was contained in or transferred by any of those pieces of equipment. And we're able to determine then whether or not your employee misappropriated that information or sent it to somebody else or handled it improperly. Allowing employees to use their own personal computers, laptops, phones, just puts your proprietary confidential information in the hands of the employee, which is not what you want to do. Additionally, even if the employee does misappropriate it, if the phone's returned wiped or erased, or our forensic experts say, look, if they bought one of these software programs that eliminated any chance we could figure out what was on the equipment or what was transferred on or through it, that also works in court. there'll be a benefit to you in court to be able to say, look, if he was innocent, why did he wipe his phone? There's also another business benefit I think you get by getting your equipment back, is you know who he's been contacting. To the extent the exit interview doesn't go well, or he declines the exit interview, or you don't get the information you think, or he doesn't cooperate in the next employee taking over his position, you should have a lot of that information recoverable by the equipment they return to you. So we think it's important that you got to limit an access and know who's got access to your, limit the access and know who has access to your confidential proprietary information. And to the extent possible, keep it on your server and your equipment.
What statutory and common law protections are there for your business information?
Well, we discussed it, generally we found they're inadequate, but let me go through those if I can. We talked about copyright, trademark, and patent, and they all provide a statutory remedy for anyone who violates or breaches your copyright, your patent, or your trademark. And often those require some sort of notice to the violator. And then after that, if the violator doesn't cease and desist, you're able to recover statutorily damages and recover lost profits they may have earned using it, and in some cases even attorney's fees. So that's one protection that's out there, but not all of your confidential proprietary information fall within those categories of federal protection. The next is there are case law and common law that talks about theft and employees stealing information, stealing proprietary information. Always difficult to prove, difficult to convince a prosecutor to provide criminal charges, but that's always a possibility. Again, what we've found with most of the criminal prosecutors is unless you can show a dollar amount in actual cash stolen by the employee, it's just too difficult for them to put a case together and and get a successful conviction. So often that's difficult. There is the federal protection of trade secrets, which also has a criminal aspect. There have been some successful prosecutions that federal prosecutors have undertaken, but generally, from what we can read from the prosecution of the cases, it has taken a tremendous amount of effort by the employer to provide that evidence. I think one was a paint manufacturer whose employee was stopped at the airport on the way to China and had a computer full of paint formulas. And certainly those exist. There is some criminal prosecution. There is also under the Federal Act the civil action to obtain damages or injunctive relief to protect your proprietary and confidential information and trade secrets. Again, you need to evaluate with your attorney whether that's the quicker, faster way to get relief or whether state court is faster. Almost all state courts do recognize interference with contracts, interference with contractual or economic expectancies. Those are claims you can raise. Theft is certainly one. And there's generally enforcement both in terms of damages and injunctive relief. We found that state courts tend to act faster and tend to act faster when we have documentary evidence that the defendant was aware that they were proprietary and confidential information. That's usually by having them sign a non-compete, a non-disclosure, a trade secret agreement. So they will acknowledge, and the court can see they've acknowledged that they understood they were working with information and that did not belong to them, and they couldn't take it and use it somewhere else. So those are the remedies, but it's easier to pursue any of those remedies if you have policies and procedures in place. Those are written policies. You have employees acknowledging those policies. You have policies that are actually enforced and followed, such as limited access to the confidential and proprietary information. And in some instances, in exit interviews, get acknowledgments that they understand those are the policies and procedures, or even if they refuse an exit interview, to send them a letter reminding them that that belongs to the employer and they can't use or disclose it.
Yeah, that's outstanding. And there are certain things that should be put into place, like you said, by every business owner that can help protect that information, even if they don't necessarily have all of the different patents and other issues that are available to them. Is that correct?
Well, that is correct. I mean, most of the situations we see are really not patent, copyright, trademark infringements. It's information that really doesn't fall into those categories, but are critical to your business that make the difference. We also think that by having these policies and procedures and having something that new employees sign, so they realize that employees are asked to sign on their exit interview, or at least address with the exit interview, I think to a lot of employees, they then understand that they have a moral, if not legal, obligation not to take that information. If you don't say anything and you don't tell them, that's mine, that's the business's, that stays with the business when you leave, they feel free to take them. But there are a certain number of employees, and I think everyone hopes they're the employees they have, that once they understand that belongs to the office, just like the stapler or the pad of paper, I don't take those. They don't take them.
Right, okay. What duties do you have to others to protect business information?
I touched on that a little earlier. Typically, when you're working with someone else and they provide you with their proprietary information, they will ask you to protect that. And usually the protection is to the same extent you protect your proprietary and confidential information. Sometimes, we've drafted them certainly for our clients, depending on the level of importance of that information we'll be sharing or receiving, we're much more specific in how you handle it, what you can do with it, and what becomes of it at the termination of the relationship. Usually it's destruction. Usually it's destruction followed by an affidavit by an officer of the corporation confirming it's been destroyed, all notes have been destroyed. But typically that would be a contractual obligation. Certainly if you're working with a vendor or a customer that sees no need to protect its confidential information when working with you, your obligations are not as high and may not exist. If the customer comes to you and says, here's my formula to make my product, here's the suppliers I want or the raw materials I want for my product, go ahead and make it for me and let me see if I'll buy it from you. If they don't ask for any protections, my guess is they don't have one. They don't have much by way of protection. There's little in the common law that would protect them, or in the commercial, the Uniform Commercial Code or most statutory state commercial laws. If they voluntarily disclosed it, if you've learned it from other sources without any obligation to keep it confidential, your liability to them or your obligation to them, excuse me, from a legal perspective is probably minimal. Whether or not you have some moral or some ongoing business obligation to keep it confidential is a topic for another day. But from the legal end, unless you have some written agreement, you probably have minimal obligations.
Okay. What steps do you take to protect your business information?
Certainly that's one of our conversations with our clients. You know, what steps do you take then? Now you've told me you've got confidential information. In order to protect that confidential information, you need to engage in a course of conduct that would evidence the fact that you have confidential information, it has value, and you have taken steps to protect its value. So at a minimum, we start with employees need to be told. An employee handbook, a policy or a procedure. Typically with this, if it's important for you, on employment, on promotion, typically there's a short acknowledgement to the people or the employees rather that will have access to create that information. And that acknowledgement would say something to the effect of, I understand my employer has confidential and proprietary information that may include customer lists, formulas, processes, and I understand that it belongs to the employer, that the termination that I may not use or disclose that information to any third party, I can only use it for the benefit of my employer, and on the termination of my employment, I will give back or not take any of that information. Just that acknowledgement alone is often a real benefit for your business. Second, you ought to employ policies or procedures in a handbook or otherwise to say, how do you handle that information? Customer contact information, markups, who has it, where it's going to be, and who can use it and how they use it. That information ought to be kept somewhere. It is kept somewhere, but ought to be kept in a place that it's only accessible by people who need to know or use that information. Third, you need to track who has access and when they have access to it. Again, it depends on your business. If it's something the purchasing manager has to have on his desk and open every day, I guess he does. If it's something that needs to be accessed only in particular situations, what was my markup last time on the sale of this product to this particular customer? Then it ought to be tracked as who accessed it, when they accessed it, and for what purpose. We talked about using employee-owned computers, phones, laptops, things like that, in which they come back to the employer. It should be specified somewhere in your policies and procedures that they're to be returned intact without any wiping, erasing, or discarding of information. Depending on where you are, we had employers that, where you are financially, employers that used to track activity on their Xerox machine, their photocopy machine. So they would know, gee, in the middle of the night, somebody came in there, entered his code, and download or copied 500 pages in the middle of the night, the day before he left. Access to other computers and who downloaded information, how they downloaded information. You ought to be working with your IT department to understand that you'll have an ability to determine that when an employee leaves. Did he put a memory stick in his computer and download everything, and when he did it, and how he did it, and how much he downloaded? That should be something that you should have an ability to do if you need to enforce any of these agreements. So there's really a plethora of things you should be doing to protect your confidential information, but I think the theme overall is you've got to demonstrate it's valuable and you've done things to protect it so it doesn't get misused or disclosed improperly.
Okay, great. Do you have employment agreements and handbooks to protect business information?
Another question we always ask our employers, and I touched on this before, if you don't, and you choose not to have a handbook, you're a small entity, or you don't want to make those kind of, have that binding on the employment at will situation, at least have some acknowledgments of your employees acknowledging that you do have confidential information and its limits on when they can use it, when they can disclose it, and the like. But typically, a lot of our employers have a more broad sort of policy or handbook. And in that case, we need to set out in that handbook so it's clear to the employees as to what your proprietary and confidential information is and how it needs to be protected. It's not theirs, even if they generate it. I mean, certain employees sit there and think, well, I'm the one who went to the yellow pages, or I went here and found this information and found that information, and I did the 50-state study to find out what we could sell in particular states and how to do it, what licensing requirements. I did the work, I should keep the work. Our handbooks and other policies need to make it clear to that employee he doesn't own that after he does that work. You paid him for it, he did it during work hours, and it's yours. As a sidelight, there's also some discussion, if you're particularly in the manufacturing area, as to whether or not inventions or improvements to products belong to you, or the employer, or the employee. In those cases, most states require that there be an agreement that says inventions or things they came up with that benefit a business such as yours during the business, his employment by your business, belong to the business. And they're assignable to you as well as any rights that may come from those documents. And we typically provide the invention agreement either as part of an employment agreement or separately, depending on the nature of the business and the employment.
Okay, great information. Do you require vendors and other third parties to protect your business information?
Another source of defense when someone steals your proprietary information and claims it really wasn't proprietary is you tell everybody about it. You tell your vendors, you tell your customers, you tell third parties, you tell suppliers, raw material suppliers, what your needs are because this is the process you use or the formula you have. In those cases, we always advise our customers, our clients rather, that when they're in those situations is to provide one of those agreements we talked about before, a non-disclosure agreement, NDA, which you would require the vendor, the customer, or whatever third party you're working with, a consultant, to sign so that it is clear contractually that the proprietary information is yours. They can use it solely for the purpose in which you've given it to them. And at the end, they can't use it, they can't disclose it, and they either destroy it or return it to you and confirm by an affidavit of an officer of that company that it was done. It's a typical situation. I don't think it's difficult to negotiate those. We use generally a form agreement we've prepared for our clients, and it doesn't change very much. It generally provides that the information, there's usually a time limit, depending on what the product is or the information. Sometimes it's as short as 2 or 3 years. After that, the non-disclosure provisions are no longer enforceable. It could be a formula that lasts almost as long as the formula remains proprietary. But it's important to have those agreements because if you're willing to give the information to vendors or customers that could then just disclose it to your competitors, it's hard to be able to convince a court that it's really protectable information.
Okay, good. Last question we have is, can you protect your business information with patent, copyright, or other actions? And I know we talked a little bit about this. Any additional comments?
Just a few. Those certainly are good protections. If that's the kind of information you have, certainly I'll start with trademarks. Certainly once you've developed a trademark, a slogan, a logo, a product design, a product name that has value, you want to protect that. And trademark is really the way to do that. And, we've run into situations where we've had real estate developers, and they just like the name of a particular real estate development, decide to build houses, and we're 50 miles away, we'll use the same name. But you find out somebody's trademarked that, and that has some real value to them. They're putting $500,000 houses under that name, and you're building $200,000 houses. So they really see some protection to having the trademark that they have. So that certainly can protect those kinds of things. And conversely, before you start on developing your logo, or once you've developed your logo, your brand name, your product name, it makes a whole lot of sense to punch it through the U.S. Patent and Trademark Office to make sure somebody else doesn't have that name. Nothing's worse probably than paying for the printing for 100,000 labels only to find out you can't use them. And you've got to change your product name. You've already launched, you maybe have a website, who knows. So certainly those protections are good. For patents, great to have them. And because you're bringing a patent action for a violation of your patent or your trademark or your copyright, doesn't prevent you from also seeking the protections of the Federal Trade Secrets Act or any state laws or state acts. So those are certainly important, but I think the most important, though, is you need to take action to protect your proprietary or confidential information. You can't really rely on those acts sitting out there to protect you. One is employees may not know, vendors may not know, they can't just take it. That you gave it to me for free and I got it, you let me use it for whatever I want to use it for. But more importantly, when you go to seek to defend the proprietary information and your protection of trade secrets, if you haven't taken the actions to protect them, it's difficult to get a court to protect them for you.
Great information on protecting confidential business information. Doug, do you have any closing comments?
Well, just kind of where I started, most businesses probably think this doesn't apply to me. But I think if you work your way through or think your way through of why is my business different than yours, your competitors? How can I prosper when they don't prosper? And what information do I have that's unique to my business that if my competitors had, it would make it difficult? That's your proprietary and confidential information. And that's the information that has value to your business, not only in the operation of your business, but when you go to sell your business. Any competent purchaser is going to say, well, you know, what's the secret sauce, and what have you done to protect it? So how do I know when I buy your business, I get it, and not your competitors, and it's not the same as everyone else? So it may take a little thinking, but it's rare that I find a business where there isn't something protectable, and depending on what it is, it has an effect on the level of protection you should engage in. But at least this minimum or floor of protection is always appropriate.
Well, thank you, Doug.
Thank you.
If you've enjoyed today's event, feel free to explore other opportunities as presented by Doug and other members of our team on PocketExperts.Solutions website. Thank you for spending time with us, and enjoy your journey to achieving your goals.